Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. So, this is breaking news. Judge Glanville on the Young Thugs case for the trial that's happening has been relieved from the case. And I have the full order for that motion that was filed to actually recuse him from the trial. So let's hop on into it. All right, so this is the signed order that went into effect. It was filed actually this morning at 11:29 a.m. And exactly when they signed it, but they signed it today. So let's hop on into it. All right, so we have the order on this to recuse Judge Glanville. This is the case. This case is before the court to consider various motions to recuse, including defendant Diamante Kendrick's motion to recuse Chief Judge Earl Glanville, filed on June 12th, 2024. Kayla Bumpus' motion to quash the show cause order and or to recuse Judge Glanville, and then defendant Jeffrey Williams' motion to disqualify recuse Judge Glanville from all further dealings in the above reference in the minute supplement. Man, so little Woody's attorneys, like, we gotta get them out of here. And that is Kayla Bumpus. Well, she's actually she's on Little Woody's case, but she's, how can I explain this? Like, you have a main attorney that's on the case, and then you have assistant attorneys that are not really, but they're there to assist when needed. But it's a whole lot of drama in this case. And then you have, of course, Young Thug, his attorneys that file. So everybody wanted to get this judge off of this case. He has, I don't even, it blew my mind when they started this RICO trial. And from the get-go, this judge has been, and I'm gonna say it, a nuisance to the trial. He hasn't been fair. He's been having secret meetings behind. It's happened. Facts as to why they hadn't granted this order. The specific facts necessary to determine. So when you file a motion, you have to provide documents and evidence that your motion. So the specific facts necessary to determine these recusal motions are well documented in affidavits, court filings, certified transcripts, and video recordings available on YouTube. Having considered the record evidence and applicable case law, courts find the following. Ooh wee. All right. So findings of facts. These recusal motions arise out of the multi-defendant persecution brought by the Fulton County District Attorney's Office alleging gang and associated crimes. Although there were 28 defendants named in the indictment, only 6 were being tried as of June 7, 2024. The motions to recuse all arise from the same circumstance related to state witness Kenneth Copeland, aka Little Woody. On June 7, 2024, the state intended to call Kenneth Copeland to testify. Prior to his testimony for Mr. Copeland, Jonathan Melnick appeared and indicated in open court that Mr. Copeland did not wish to testify, intended to invoke his Fifth Amendment privilege against self-incrimination. Judge Glanville brought Mr. Copeland into court and discussed with him the effect of an immunity order Judge Glanville had entered that granted immunity to Mr. Copeland. Judge Glanville specifically advised Mr. Copeland that if he invoked the Fifth Amendment and refused to testify, the state would ask for Copeland to be held in contempt and jailed. Judge Glanville also advised that if asked, Judge Glanville would jail Mr. Copeland for refusing to testify. After that discussion, Mr. Copeland spoke to his attorney and then indicated he would testify. Once called, Mr. Copeland was asked to specify his age, and instead of answering, he stated, "I plead the fifth." Judge Glanville excused the jury and then advised Mr. Copeland in open court that he was in contempt and ordered him jailed until Monday, June 10th, 2024, at which Judge Glanville told Mr. Copeland they would revisit Mr. Copeland's willingness to testify. Mr. Melnick spoke to Mr. Copeland and then reiterated to the court that Mr. Copeland still intended to invoke his Fifth Amendment right if called as witness. Judge Glanville indicated he would revisit the issue with Mr. Copeland on Monday, June 10th, 2024 at 8:30 a.m. The court was adjourned for the day. On June 10th, 2024, at approximately 9:10, Judge Glanville met with counsel for the state, Andrea Love, and standing counsel for Mr. Copeland, Kayla Bumpus. The meeting took place in Judge Glanville's chambers. Now, this is the part in his chambers. Counsel for the trial defendants did not participate. I'm gonna repeat that. Counsel for trial defendants did not participate in the meeting and were not aware that the meeting was taking place. Now, why is that? Why is that? The transcript, and I'm going to do a members and we're going to go over that transcript. The transcript reflects that Miss Love told Judge Glanville that she wanted the meeting to both impress upon Mr. Copeland the risk of refusing to testify and allow Mr. Copeland to ask questions before he testified. Miss Love also expressed concerns to Judge Glanville about Mr. Copeland's representation. Miss Bumpus, Miss Love, and Judge Glanville also discussed the scope and effect of the state's grant of immunity to Mr. Copeland. Mr. Copeland was then brought to Judge Glanville's chambers, where he spoke with and asked questions of Mr. Bumpus, Judge Glanville, and Simone Hilton, counsel for the state who had joined the meeting. During that time, the state advised Mr. Copeland that he could remain in custody until the conclusion of the trials of defendants in the case, not just the six currently on trial. Judge Glanville discussed the state of Georgia section 245-507 with Mr. Copeland and his rights and responsibilities after a grant of immunity. Mr. Copeland spoke privately with his standing counsel, Ms. Bumpus, and then advised the court that he would testify. After the meeting and immediately before Mr. Copeland was brought out to testify, defendant Williams' lawyer, Brian Steele, advised the court that he was aware of the in-chambers meeting that morning. Mr. Steele objected to the ex parte meeting in a lengthy colloquy of what? A lengthy colloquy occurred between Mr. Steele and Judge Glanville, in which Judge Glanville inquired how Mr. Steele became aware of the chambers meeting. Y'all back there having a meeting and thought nobody was going to find out about it. Y'all give me a second. Let me put my dogs out right quick. Whew, dogs are like kids. I got kids and dogs. All right. so Judge Glanville was like, wait. How y'all find out that we had a meeting? Yeah. All right. So Mr. Steele declined to reveal the source of his information, and Judge Glanville held him in contempt, though Mr. Steele was allowed to remain in the courtroom on behalf of his client, defendant Williams. Ultimately, Kenneth Copeland did testify on June 10th, 2024, and was later released from custody. The next day, Judge Glanville issued a show cause order requiring everyone present at the ex parte meeting to appear and show cause to as to why they should not be held in contempt for disclosing information about the ex parte meeting to defense counsel. Why are you having a meeting without the other counsel for this for the defendant present? And now you trying to what? An amended show cause order was later entered, setting the meeting for June 1st, 2024, for an in camera review of the transcript of the ex parte meeting. This is like a soap opera before our eyes, man. The first motion to recuse followed, filed by Diamante Kendrick on June 12th, 2024. Mr. Kendrick's motion seeks to recuse Judge Glanville for his involvement in the alleged improper and coercive ex parte meeting with the state. On June 14th, 2024, Judge Glanville denied that motion. Judge Glanville determined the recusal motion was timely, supported by an affidavit, and on a cursory review contains assertions of fact to support the allegations of bias and partiality. However, Judge Glanville ultimately determined that because there was no way to verify the veracity of the information contained in the affidavit and there was no actual evidence of the extent of the discussion during the in chambers meeting. I'm throwing up my quotation fingers, the secret meeting. The affidavit was legally insufficient, and the motion to recuse did not require referral to another judge for consideration. That's why the ex parte transcript came out. I'm gonna read that in members. On June 14th, 2024, Caleb Bumpus then filed a motion to quash the show cause order and or to recuse Judge Glanville from presiding over any contempt action against Mr. Bumpus resulting from the alleged disclosure of the ex parte meeting. On June 17th, 2024, Jeffrey Williams, Young Thug, filed his motion to recuse Judge Glanville. Divorced from his hyperbole, Mr. Williams' motion and supplement also to seek to recuse Judge Glanville because of his involvement in the ex parte meeting, which Mr. Williams also alleges was improper and coercive. And it was. Mr. Williams' motion alleges both actual bias and the appearance of bias because Judge Glanville allegedly participated in the accusatory process when he met with Mr. Copeland, and Judge Glanville became embroiled in a controversy when he held Mr. Williams' lawyer Brian Still in contempt. You held this man in or this attorney in contempt because he found out y'all had a secret meeting. On July 1st, 2024, the day appointed for the parties to review a redacted, listen to this, a redacted, so that means information that is blacked out. Why? But anywho's, that was the day that the parties to review a redacted transcript of the ex parte meeting. Judge Glanville announced that he was releasing the entirety of the transcript of the ex parte meeting and was taking judicial notice of and making a record regarding certain matters associated with the ex parte meeting. Most of what Judge Glanville relayed uh, was a collation of record evidence about recent circumstances in the case. Judge Glanville also explained how he became aware of the state's request for an ex parte meeting. In addressing the circumstances of the contempt against Mr. Steele, Judge Glanville explained the court's purpose and concern in pursuing information about the security and confidentiality of his chambers. Judge Glanville advised that he had not instigated an investigation into the surveillance footage, but had reviewed such footage for timeline and security. Judge Glanville then explained his view that the ex parte meeting was proper under Georgia law and outlined relevant law that supported his inherent authority to hold such a meeting. So pretty much he applied Georgia law to say, hey, my secret meeting was allowed. It was justified. Judge Glanville maintained that no one gained a tactical advantage as a result of the ex parte nature of the meeting. Judge Glanville also questioned defendants' rights to be present at the ex parte meeting because the issue under discussion was between the state and a witness who was represented by counsel. After record, After making this record, Judge Glanville announced that the show cause hearing was canceled and that the recusal motions filed by Mr. Kendrick, Mr. Williams, and Ms. Bumpus were referred for consideration by another judge in accordance with the Uniform Superior Court Rule 25.1 through 25.7. The motions to recuse were then assigned to this court for consideration. Now, here's the legal framework to back up why this judge should be recused. Motions to recuse are governed by a specific legal framework outlined in Rule 25 of the Uniform Rules of Superior Court. A party seeking recusal must file a timely motion supported by an affidavit, clearly stating the facts and reasons for the belief that bias or prejudice exists. The affidavit must be definite and specific and describe circumstances of extrajudicial conduct or statements which demonstrate either bias in favor of an adverse party or prejudice toward the moving party in particular, or a systematic pattern of prejudicial conduct towards persons similarly situated to the moving party, which would influence the judge and impede or prevent impartiality in the action. You having a secret meeting with the state that the defendant's attorney had no clue about. Sus all over it. USCR 25.2, bare conclusions and opinions are not legally sufficient to support the motion or warrant further proceedings. Once such motion is filed, it is the duty of the assigned judge to temporarily cease to act upon the merits of the matter and assess the timeliness and legal sufficiency of the affidavit and alleged facts. USCR 25.3 says if all three criteria are met, example, the motion is timely, the affidavit is supported, and all the facts are alleged, that if all of those are there, then that does warrant recusal, which is another judge will be assigned to hear the motions to recuse. When considering a motion to recuse, the assigned judge should be guided by Rule 2.11 on the Revised Code of Judicial Conduct, which provides that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. The standard is objective from the perspective of reasonable, fair-minded, and impartial persons rather than affected judge and other interested parties. So here's the thing. A motion was filed by all three from Little Woody, Young Thug, and Kayla Bumpus, who is on the team, Little Woody's team, right? And so they all are filing this motion to recuse. So when you're filing it, how the process normally goes is we file the document goes to the court clerk, the court clerk sends it to the court coordinator, and the court coordinator sends it to the judge to review. So if you have these motions to recuse the judge, and who are you sending these motions to, and who's reviewing it? Of course, Glanville is reviewing it. So right there, how are you reviewing motions about yourself? Okay, so I want you guys to have that in your head. So that's why you have to assign another judge to review that motion to see if all factors are included in that motion, to say, okay, this does call for the removal of, or start the removal process for the judge. Let's see what I left off. If a motion to recuse satisfies the three threshold criteria, the assigned judge must refer the motion for reassignment and may not oppose the motion. The judge whose recusal is sought may not respond to the motion or attempt to refute the allegations, which stand denied automatically, no matter how false or even defamatory the judge might know or perceive the allegations to be. So that's why it was signed to another judge, but at the same time, Judge Glanville can't say nothing about it. This is all that is saying. Whether it's true or it's not true, you can't say anything about this. This is not your opinion, does not matter in this case. If they find that everything in the motion was factual, then they can go ahead and proceed to reassign the case to another judge. A judge cannot become actively involved in presenting evidence or argument against a motion seeking his recusal without the defense itself becoming a basis for recusal. So here is the and they actually cited Isaac versus State. I'm sorry, you hear my dogs barking. Says a judge has no interest in sitting on a particular case. At most, his interest lies in protecting his own reputation. His efforts at defending himself against a motion to recuse will inevitably create an appearance of partiality. One reason that is One reason is that if he defends himself, he becomes an adversary of the movement for recusal. The adversarial posture may create an antipathy. Man, I can't even talk. Antipathy, which I cannot talk. Persist after the motion to recuse is denied. Y'all forgive me for that. um then it goes on to say this is the analysis and this is discussion. So in this order, it gave us the facts, then it gave us the law that stands behind those facts. Now they are analyzing, and here's the discussion. So now you're going to see how all of this plays in together. Here, Judge Glanville had previously announced on record that the motions were timely and supported by an affidavit. In transferring the case to another judge for reconsideration, Judge Glanville necessarily determined that the third criteria was satisfied. Example, the recusal might be authorized if the fact alleged in the motions were assumed true. Therefore, Judge Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. It is worth noting that this court agrees generally with Judge Glanville's assessment of the propriety of the ex parte meeting. While the meeting could have and perhaps should have taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. However, in his order denying defendant Kendrick's motion and in the process of making his record on July 1st, 2024, Judge Glanville added facts, provided context, questioned the veracity of allegations, and otherwise explained his decisions and actions and argued why those actions were proper. So he got the motion and he reviewed the motion and he said, okay, all of the facts were present. Well, I don't want to say the facts, the criteria. All three of the language for the criteria was present. So what he should have done was reassign that. That's what it's stating right here. Let's see. While it may be appropriate for the judge to disclose information relevant to his potential recusal, such a disclosure must be made in a way that is as objective, dispassionate, and non-argumentative as possible, so that the judge is not reasonably perceived as a hostile witness or advocate. In presenting his record as to the recusal issues in ruling Kendrick's motion, Judge Glanville evaluated and accepted the truth of his own factual allegations mandating his recusal. This is funny. The judge is pretty much reading stuff about why he should be recused. But as a judge, you got to do your due diligence and you got to follow the laws of the state. So this is crazy. This is crazy. The court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motions were denied. But the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling of his case. So look at this paragraph. So the court is pretty much saying that regardless of whatever is going on, they still feel that Judge Glanville can do his duty as a judge and that he would make that's crazy. That is crazy. But what it's saying on the flip side, because they don't want to lose favor with the public, and they don't want the public to lose um how can I say this? They don't want us, the people, to look down on the judicial system. Because what we say, if they would have kept that man up there, we would have been like, the we already see that with Trump, but that's neither here nor there. If that man would have stayed there, then our confidence in the judicial system is at an all-time 0%. So they did this in the best interest of the public. So they excused him from handling this case. So it says, based on the foregoing, this court hereby orders as follows: Defendant Diamante Kendrick's motion to recuse Chief Judge Glanville is granted. Caleb Bumpus' motion to quash the show cause order and or to recuse Judge Glanville is denied as mute. So that's still going to happen. Defendant Jeffrey Williams' motion to disqualify recused Judge Glanville from all further dealings in the above referenced case as amended and supplemented is granted. The clerk of court shall reassign this case using the court's case assignment procedures. And that was signed by the Honorable Rachel Cross. Oh, man. That is awesome. So I haven't, every now and then I will, listen to Young Thug's trial. It's just right now for me, it was just like everywhere because of this judge. But I am glad to see that Judge Glanville is not going to be up there anymore. Once they reassign the case, I just feel that the case is now going to move forward. He's going to get a fair trial. When we submit, or not we submit, but when there is a jury trial, the whole purpose is to have a fair jury and a fair trial. When you have all of these things being brought up, secret meetings and holding people in contempt, it just becomes a circus at this point. And that's not fair to Young Thug. This has been going on that this has been going on for a while. Trump's case took a shorter version than Young Thug's, and it's truly sad. But now I hope that Young Thug gets a fair trial. The judge, whoever is going to be, I feel like they're going to do their due diligence and just make sure that everything goes in the right direction. So what do you guys thinking about this? Leave it in the comments. Don't forget to like, share, and subscribe. Until then, peace. I'm out.